On this side of the law, on that side of the law, who is right?
Well, hello, everyone out there in podcast land. It's time for another episode of Law Dawg. I'm Mark, the attorney Judson.
Jonathan, Law Dawg, Fontenot from the marshes of Cameron Parish.
To the courtrooms of Calcasieu, this is Law Dawg, bringing common answers to common legal questions. Today's episode, Law Dawg, is owner finance purchases of land. Don't bank on them. What do we mean by that?
Don't bank them. I don't know. Owner finance means you don't use a bank.
Right. Who's doing the financing?
You're back. Gets the owner.
Yeah, the owner or the seller.
Right. So I don't know what the problem is, but you don't get your money out just like a bank. You're not getting a lump sum. You get monthly payment with an interest. What's the problem?
Well, how do you go about doing it?
Yes.
Well, first of all, the problem is you're not getting all the money up front. That's
right.
Number one. So what instances are going to happen where a seller of land is okay selling owner finance?
They're not using it to buy a new house or do.
Well, yeah, I guess they don't need the money that bad.
Right.
Probably they have a situation where the buyer, for credit reasons.
Oh, yeah.
Or, the buyer just has a great job in good ability to pay, but just had some unfortunate incident in their life where they had a bankruptcy, or they had an illness, or they had a spouse die, or they had a child with some severe medical, they had all kinds of debt. They just can't get a bank loan because their credit ratings are so poor. But the seller realizes that they have the ability to pay. So instead of passing up the deal, they're going to take monthly payments until paid. And that's what an owner finance is all about. Instead of a bank loaning the money and giving all the money to the seller in one lump, the seller is really like the bank and is going to finance out the purchase of the land. How do we go about doing that?
Bond for deed.
What is a bond for deed?
A contract. The owner finance contract, right?
And how do they work?
Simply like there's no bank involved. You pay the owner a down payment, I guess, to kind of secure the loan, and then you make monthly payments. And
who owns the property?
The person who selling the house remains the owner.
Yes, the bond for deed seller. The title does not leave the owner's name.
So the seller should have insurance on the property, or have the buyer insure it, because if something happens to the property, the landowner is still...
The seller owns it.
Yeah.
Right? So the seller owns the property in a bond for deed situation, like rent-to-own kind of thing. The seller is a glorified landlord. The seller is still the owner. The seller is still responsible for all the ownership responsibilities. An insurance company will not insure it in anyone's name but the owner.
Oh, wow.
And then taxes, it's the owner's responsibility. Now, you can contract that the bond for deed purchaser, the lease purchaser, the rent-own purchaser is going to pay for all this stuff.
Pay for it, but even though it's your insurance, you can have them pay it.
Yeah,
your taxes.
Put it in the note.
Have them pay it.
Put it in a note. You can do all that. The problem is that it's your land. It's the seller's land, seller's responsibility. Now, what's the upside to that? What's good about that?
No foreclosure costs.
Right. And why is that good? What's the big deal about foreclosure?
I think foreclosure is minimum $5,000.
Yeah. As a practical matter, and I know in Calcasieu, you're going to pay the clerk of court alone $2,200 just to walk in the door.
Right.
You're going to have to pay a lawyer at least probably $3,000. So $5,000 is probably going to be a minimum to foreclose. That's when the seller is not the owner. Now, when the seller is, when it's a rent-to-own situation, the seller's a landlord. So what does the landlord do if the bond for deed buyer can't make the payments? What's the landlord do?
You evict.
Right. Now, there's some tricky little nuances there that you got to be aware of. The eviction has to be kind of equivalent to fair market rental value and stuff like that. Down payments can be tricky in that situation. But nonetheless, the bond for deed seller has an easy remedy to get rid of a defaulting buyer.
And they don't have to return the down payment, right?
Well, that's another that's too complex for this. It's possible. You got to do it just right to avoid that.
Okay.
All right. You got to do it just right to avoid it. But that is a risk. Okay. But the general principle is that a rent-to-own seller, all they got to do is evict. Now, what's the other alternative to bond for deed or rent to own in an owner finance arrangement?
Vendor's lien.
Vendor's lien. What's the big difference? What's a vendor's lien?
$50. I don't know what a vendor's lien is. I'm
Well,
assuming,
who owns the land?
assuming the title does transfer in the meantime.
In a vendor's lien, the seller literally sells the property to the buyer. So the buyer literally becomes the owner. Title transfers, and then the seller has a vendor's lien or a glorified mortgage.
But there's no bank involved in this.
No, it's all owner finance. But the seller has a lien. So the seller doesn't own the property anymore, but they got a mortgage. It's called a vendor's lien.
But they don't pay. Do you have to do the foreclosure thing?
Correct.
Okay.
So when title transfers to the rent-to-own or the owner finance buyer, then the owner finance buyer, they're the ones that own it. They're the ones that's got to pay for the insurance. They're the ones that's got to pay the taxes. They own it. It's in their name. So if they default, then although you're relieved of all those ownership responsibilities, you got to go through the much more expensive process of the vendor's lien foreclosure.
Gotcha.
So two ways to go: rent to own or vendor's lien. Rent to own, seller owns the property, has all the responsibilities of ownership. Vendor's lien, buyer owns the property, has all the responsibilities of ownership. First option, easier to get the land back through eviction process. Second option, harder to get the land back because you got to go through a foreclosure process.
Is there a limit to interest rate you can charge under either?
Usury regulates that. So
Okay.
not really.
Not really.
Not as a practical matter.
Okay.
Nobody's going to pay 40%. Yeah. But in an owner finance arrangement, you are going to typically pay more than the market rate. So let's say the market rate from a bank is like 7% annual interest on real estate. Owner finance, it could be 10, 11, 12, something like that.
I gotcha.
So that's why they do it. So owner finance or vendor's lien, know the difference, particularly if you're the seller and if you're the buyer. Well, I think that's going to wrap up this episode of Law Talk. I'm Mark the Attorney Judson.
I hereby evict you from the rest of this program.
Or
shout out to Law Dawg.
We're foreclosing we're taking back the ownership. Thanks for tuning in. Check out the bottom of the screen for references to other episodes of Law Talk. Thanks for watching.